looking at Federalist 83, Part 5. We'll start with paragraph 22. Please make sure that you listen to Part 1 of this Federalist. The book that's on screen, it's another one of the books that might be helpful in understanding the Federalist Papers a little better. It's called The Federalist Design for a Constitutional Republic by George W. Carey, C-A-R-E-Y, and it's the University of Illinois Press. University of Illinois Press. I'll start reading from paragraph 22. As on the one hand, the form of the provision would not fulfill the intent of its proposers, so on the other, if I apprehend that intent rightly, it would be in itself inexpedient. I presume it to be that causes in the federal courts should be tried by jury, if in the state where the court sat, that mode of trial would obtain in a similar case in the state courts. That is to say, admiralty causes should be tried in Connecticut by a jury and in New York without one. The capricious operations of so dissimilar a method of trial in the same cases under the same government is of itself sufficient to indispose every well-regulated judgment towards it. Whether the cause should be tried with or without a jury would depend on the great number of cases, on the accidental situation of the court and the parties. So Hamilton here in this Federalist is answering some of those critics that say you mean to do away with all the juries because you mention in the Constitution that the criminal cases can have a jury trial, but you haven't mentioned anything about civil cases having jury trials. And Hamilton says, no, we wanted to leave this to the legislature of the country, to the Congress, to decide which cases should have jury trials for civil cases, not criminal cases. So, because we don't want too many laws to be written in the Constitution trying to cover every detail. We know it's not going to happen. But this is not my estimation the greatest, but this is not, in my estimation, the greatest objection. I feel a deep and deliberate conviction that there are many cases in which the trial by jury is an intelligible one. I think it is so particularly in cases which concern the public peace with foreign nations. That is, in most cases where the question turns wholly on the laws of nations, on international law. Of this nature, among others, are all prize causes. Juries cannot be supposed competent to investigations that require a thorough knowledge of the laws and usages of nations, and they will sometimes be under the influence of impressions which will not suffer them to pay sufficient regard to those considerations of public policy which ought to guide their inquiries. Their world, of course, would of course be always danger that the rights of other nations might be infringed by their decisions so as to afford occasions of reprisal and war. Though the proper province of juries be to determine matters of fact, yet in most cases legal consequences are complicated with fact in such a manner as to render a separation impracticable. So another case that he says a jury trial is questionable is when you're dealing with stuff that has to do with international law. He says because people are not informed enough, your average person, to know the intricacies and delicacies, niceties of different cases. So that will create problems. That's why he says on this part I'm hesitant to say a jury trial is a good thing. It will add great weight to this remark in relation to prize causes to mention that the method of determining them has been thought worthy of particular regulation in various treaties between different powers of Europe, and that pursuant to such treaties they are determinable in Great Britain in the last resort before the king himself in his Privy Council, where the fact as well as the law undergoes a re-examination. Because remember, in a jury trial, jury is supposed to look at the facts and judge looks at the law applying to the case. So here he's talking about in the case of Great Britain, he says that the king in his Privy Council with a group of advisors close to him does this whole thing. And then where the fact as well as the law undergoes a re-examination. This alone demonstrates the impolicy of inserting a fundamental provision in the Constitution which would make the state system a standard for the national government in the article under consideration, and the danger of encumbering the government with any constitutional provisions, the propriety of which is not indisputable. My convictions are equally strong that great advantages result from the separation of the equity from the law jurisdiction, and that the causes which belong to the former would be improperly committed to juries. The great and primary use of a court of equity is to give relief in extraordinary cases, which are exceptions to general rules. And then he gives us a footprint here. It is true that principles by which that relief is governed are now reduced to a regular system, but it is not the less true that they are in the main applicable to special circumstances which form exceptions to general rules. And then he goes back in the paragraph to unite the jurisdiction of such cases with the ordinary jurisdiction must have a tendency to unsettle the general rules and to subject every case that arises to a special determination. While the separation of the one from the other has the contrary effect of rendering one a sentinel over the other and of keeping each within the expedient limits. Besides this, the circumstances that constitute cases proper for courts of equity are in many instances so nice and intricate that they are incompatible with the genius of trials by jury. They require often such long, deliberate, and critical investigation as would be impracticable to men called from their occupations and obliged to decide before they were permitted to return to them. The simplicity and expedition which form the distinguishing characters of this mode of trial require that the matter to be decided should be reduced to some single and obvious point, while the litigations usual in chancery frequently comprehends a long train of minute and independent particulars. And this is another Federalist paper. I've already mentioned this to you, the Federalist, a classic on federalism and free government. And it's by Gottfried Dietze, D-I-E-T-Z-E, and it's by Greenwood Press. So when you get interested in studying the Federalist Papers a little bit more in depth, look at these books, and also definitely look at the list of the authors I've shown you off and on. Some of these historians whose lectures and books you would definitely benefit from if you were to listen and read these lectures and books. Over the years, listening to these talks have been very helpful to me. So I hope you do the same, and then it's encouraged me to look at some of these authors' books. We will come back and read some more of this Federalist paper.